In a landmark verdict, the Supreme Court on Monday upheld the 2019 decision of the Centre to abrogate special status for the erstwhile state of Jammu and Kashmir under Article 370 and set a deadline of September 30 next year for the assembly elections to be held. The unanimous order by a bench of 5 judges, headed by Chief Justice of India D.Y. Chandrachud, followed more than a dozen petitions challenging the revocation and a subsequent decision to split the state into 2 union territories, Jammu and Kashmir and Ladakh. Before we go in for details, let's listen to the verdict of the Supreme Court.
और जो यूनानिमस जजमेंट थी, ये सुनकर बहुत निराशा हुई, बहुत अफसोस हुआ। मैं शुरू से ही कह रहा था कि 2 अदारे हैं जो इसका फैसला कर सकता है, एक पार्लियामेंट, मरकजी सरकार, और दूसरा सुप्रीम कोर्ट। जाहिर है मरकजी सरकार करती नहीं, उन्होंने तो आर्टिकल 370 को खत्म किया, कानून बनाकर नया। अब ये आखिरी हमारी उम्मीद थी कि सुप्रीम कोर्ट इसमें सुनाई करे और इसका फैसला सुनाए। 3 महीने 4 महीने इस पर बहस हुई पार्लियामेंट के अंदर, और मुख्तलिफ वकला ने अलग अलग पार्टीज को और रियासत जम्मू कश्मीर के लोगों को रिप्रेजेंट किया, और उसके बाद जो आज यूनानिमस फैसला आया, उससे मेरे ख्याल में जम्मू कश्मीर के सभी लोग, चाहे वो कश्मीर के हों या जम्मू सूबा के, वो खुश नहीं।
Now, let's see what the Apex Court's judgment on Article 370 abrogation means for Jammu and Kashmir. Article 370 of the Constitution gave special status to Jammu and Kashmir in the Indian Union and restricted the centre's legislative powers with respect to the state. It gave the state legislature to make its own laws in all matters except for finance, defence, foreign affairs and communications. On Monday, the Supreme Court held that it need not adjudicate on the validity of the presidential proclamations announcing President's rule in the UT, since petitioners did not challenge the same. The court found that no material relief could be given as the President's rule was withdrawn in October 2019. The 5-judge Constitution bench, headed by Justice Chandrachud, in its 3 concurring judgments, dealt with the question of whether the provisions of Article 370 were temporary in nature or they acquired a permanent status in the Constitution at the end of the J&K Constituent Assembly's tenure in 1957. He said Article 370 was introduced to serve 2 purposes, including the transitional purpose to provide for an interim arrangement until the Constituent Assembly of the state was formed and could take a decision on the legislative competence of the Union on matters other than the ones stipulated in the instrument of accession, and ratify the Constitution. Now let's find out what the exact position of the Constitution. Article 370 of the Constitution, which provided autonomy for Jammu and Kashmir, was drafted in 1947 by Sheikh Abdullah, then the state's Prime Minister, and accepted by India's first Prime Minister Jawaharlal Nehru. Classified only as a temporary provision, it was included in the Indian Constitution in October 1949. After 5 years of temporary provision given to Jammu and Kashmir, the provision was changed in 1954. Let's see how did the provision change. A further provision added to the Constitution in 1954 as part of Article 370, Article 35A, empowered state lawmakers to ensure special rights and privileges for permanent residents of the state. But it was scrapped with the repeal of Article 370, allowing non-Kashmiris to buy property in the region and ending local control over state government jobs and admission to colleges. After scrapping the Article 35A, let's see the reorganization of Jammu and Kashmir. But before that, let's find out what is Article 35A. Article 35A under Article 370 of the Constitution was introduced through a presidential order in 1954 to continue the old provisions of the territory regulations. The article permitted the Jammu and Kashmir state legislature to define permanent residents of the region. It forbade outsiders from permanently settling, buying land, holding local government jobs, or winning education scholarships in the region. The article, referred to as the Permanent Residence Law, also barred female residents of Jammu and Kashmir from property rights in the event that they married a person from outside the erstwhile state. Now let's see the reorganization of Jammu and Kashmir. With the abrogation of Article 370, the centre had also reorganized the erstwhile state of Jammu and Kashmir into two union territories, Ladakh and Jammu and Kashmir. Ladakh was carved out as a union territory without a legislature, while Jammu and Kashmir had a legislative body. Both the UTs are being administered by the centre appointment lieutenant governors, since no assembly elections have taken place in Jammu and Kashmir since August 5, 2019.